At this point in time, I'd like to introduce Sister Shireen Mohammed, the first speaker. She's an attorney at law for the last 17 years, in which she initially worked with the Markaz group of companies in industrial relations and law and insurance laws also. She's also in private practice since 2000. Prior to that, she has done a lot for occupational health and safety, upgrading some laws and training. Now we introduce you, Sister Shireen.
Assalamu alaikum again. Wishing blessings of Allah, each and every one of you. I will be asked to speak to you today about the laws related to the death penalty, and I will ask you to, while I speak, to follow with what is ahead there on the board. The death penalty is also called capital punishment or execution. It is killing of a person by judicial process for retribution, general deterrence, and incapacitation. The death penalty for all types of murder is death. It is mandatory punishment for murder in our law. The authority for the death penalty comes from legislation, the legislation of our lands. Section 4 of the Offences Against the Persons Act, Chapter 1108, says, every person convicted of murder shall suffer death. The Criminal Procedure Act, Chapter 1202, Section 57, gives you a guideline as to how this penalty for death is to be carried out. You can see there that it says that the person is to be hanged by the neck until he is dead. That is what the legislation says. And the President of the Republic of Trinidad and Tobago signs the warrant authorizing the execution in that manner. These two pieces of legislation have to be taken in the context of our Constitution. Our Constitution, Section 5.2, states that the Parliament will not impose or authorize the imposition of cruel and unusual treatment or punishment. However, there is another section of the Constitution that says nothing in Section 4 and 5 shall invalidate an existing law. Now that creates a controversy. The controversy has to do with the fact that the death penalty has been called cruel and unusual form of punishment at some point. Now, in applying the law and applying these pieces of legislation, the Offences Against the Person Act provision that every person convicted of murder shall suffer death, it cannot be carried out that simply. As we all know, nothing is that straightforward or simple. As a result of judicial decisions, that in particular of the Privy Council, the nation's highest and last court of appeal, restrictions have been placed on the carrying out of the death penalty. And I will show you a few of the cases that relate to this. We've been hearing in the newspaper about the Pratt and Morgan case. In 1993, in the Pratt and Morgan case, the Jamaican case, the Privy Council ruled that it was cruel and inhumane to keep a man or woman on death row for 5 years. Justice, it said, should be swift. And this is exactly in line with what our Justice Baldwin has said. Justice, it should be swift. As a consequence of this ruling, people who have spent 5 years or more on death row in countries of the English-speaking Caribbean, which retain the Privy Council as their highest court of appeal, have had their death sentences commuted to life imprisonment. However, there is the other case of the Privy Council appeal of 11 of 1995 of Guerra and Batiste, which is a Trinidadian case, which clarified that this 5-year period was not a time limit nor a yardstick. It confirmed that the requirement was simply that execution would follow swiftly as is practicable after the sentence, allowing a reasonable time for appeal. It confirmed that in the domestic appeal process, that is, in the appeal process in every single country, that the appeal should be completed within 2 years. So, with respect to that, the swiftness of the justice is so critical. Otherwise, the action of the death penalty becomes inhumane and cruel. There is also the ruling of Thomas and Batiste in 2000, which confirmed that there could not be the execution of prisoners with pending petitions before international bodies. However, this was immediately repealed by the Constitution Amendment Number 3 Act of 2000. This means that if a convicted criminal has applied to the Privy Council, they could be hanged during the waiting period. But to date, this has yet to be followed. I will give you just some of the options that are available to persons on the death row for appeal. Well, we know about the appeal to the Privy Council, but there are so many different other appeals because Trinidad and Tobago is in fact part of the international community. There is also appeal can be made by a petition to our local mercy committee, where the person can be pardoned for his criminal act. There is also, through the International Covenant on Civil and Political Rights, to which Trinidad and Tobago is a state party, there is a provision for appeal there. And fourthly, there is an appeal to the International Court of Human Rights. Now, there has been a question that has been raised as to whether the death penalty is mandatory. And this question has been raised through cases again that have gone to the Privy Council. The case of Rudal and the State. This was appealed to the Privy Council, and Mr. Rudal's attorneys raised the argument that in Trinidad and Tobago's constitution, the death penalty was not mandatory, and that the trial judge had discretion as to what sentence should be imposed for murder. This argument found favor with 3 of the law lords in the Privy Council. This decision had a ripple effect, not just in Trinidad and Tobago, where 86 men and women on death row, but the entire Caribbean, where the penalty for murder was death by hanging. Mr. Rudal's sentence was commuted to life imprisonment, as was the sentence of all others on death row. However, because of this decision, in 2004, the Privy Council, in an unusual panel of 9 judges, normally there are 5 judges who hear a case, they set about to reconsider the issue of whether the death mandatory or not. They considered the cases from 3 islands, Jamaica, Barbados, and also Trinidad and Tobago, the case of Charles Matthews. The prosecutors in all the 3 islands insisted that the death penalty was mandatory according to the Constitution. In a historic move, the Privy Council reversed the earlier decision of Markaz, and they declared that the death penalty for murder was, after all, mandatory in Barbados and Trinidad and Tobago by virtue of our Constitution. As recent as last year, the Privy Council, in the case of Ronald John and the State, in the dissenting decision of Baroness Hale, she was one of the judges, stated, it is accepted that the death penalty is imposed and executed for the crime of murder consistent with the Constitution of Trinidad and Tobago. And where the debate concerns the mandatory imposition of the death penalty in all cases of murder, irrespective of the circumstances, it is accepted that our task as the Supreme Court of Trinidad and Tobago is to uphold its law whether we like it or not. So in conclusion, there are 4 points that I need to bring to your attention. Firstly, in 1989, the then President, Ihsaan, established a commission of inquiry to look into the death penalty. The commission was headed by the Attorney at Law, Elton Prescott. The commission recommended that the death penalty remain on the statute books, but the commission recommended that there should be degrees of murder: murder 1, murder 2, and murder 3, that all killings are not murders. Following from that, we should also take note that there is an act in place at the moment, Act number 90 of 2002, of the Offences Against Persons Amendment Act, which has not been brought into operation. This piece of legislation has in it categories of murder 1, and it has not come into play as yet. Thirdly, Trinidadians' response to the death penalty. According to David Simmons, who wrote in the Journal of Translational Law and Policy, he stated in his research that 90% of Trinidadians want the death penalty. And fourthly, we need to be reminded of Section 4, Chapter 1108 and the Constitution. This is what I started with. The Privy Council has plainly stated that its judicial decisions, which can be properly described as restrictions and carrying on the death penalty, can be reversed. But that means to do so, we have to amend our Constitution. And I would like to remind you what our Constitution says, as I started from the very beginning. Section 5(2) of the Constitution states, Parliament may not impose or authorize the imposition of cruel and unusual treatment or punishment. It also refers to Section 6(1), which refers to the existing law. And I will read again, the existing law states, at Section 4, Offences Against the Person Act, every person convicted of murder shall suffer death. Assalamu alaikum.
Thank you very much, Sister Shireen. I failed to mention in the beginning that Sister Shireen also is a student